Hi, and welcome to this latest immigration law update video. In this video, I want to look at the new Statement of Changes to the Immigration Rules, which was laid before Parliament on the 10th of September 2020. That's HC 707. And below this video, I will put the link which has the Statement of Changes and the explanatory memorandum. And on your screen now is the explanatory memorandum, which explains the changes that are being made within the Statement of Changes HC 707. And what's the big headline? Well, we're seeing an end to Tier 4 students and an introduction of new student routes coming in from the 5th of October 2020. So have a look at your screen and you can follow along with me. I'm just going to give you a high-level overview. The devil, of course, is always in the detail, and do have a look at the new appendices to the immigration rules, which are contained within the Statement of Changes. So this Statement of Changes is to introduce the new student and child student rules for the points-based system. So we're going to see two new appendices to the immigration rules. That's Appendix ST for students and Appendix CS for child students. And then look at the second bullet point. There's going to be three other appendices to the immigration rules. One that's Appendix English Language, which deals with the English language provision. One which is Appendix Finance, which deals with the maintenance provision. And the third one, Appendix ATAS, which deals with the Academic Technology Approval Scheme. Now, these appendices at the moment will only apply to the student routes, but over time they'll be expanded and will cover other routes as well. So Tier 4 will close as of the 5th of October 2020, and at 9 a.m. the new student route is introduced. So what has changed? Well, the whole idea now is to bring a global system that covers EEA and non-EEA nationals. So here we are, 7.1 of the explanatory memorandum. The changes are being introduced to give effect to the government's plan to create a global visa system which applies equally to all individuals coming to the UK to work or study, including EEA nationals. Now, something to be aware of, really, this student scheme is not going to kick in for EEA nationals until January 2021. We'll come back to that in a moment as I go through the explanatory memorandum. So obviously the government set out its intent in the policy statement, the UK points-based immigration system, in February 2020, and the links in the footnote there. And obviously we had the further detailed statement on the 13th of July 2020. So 7.2, the student and child student routes, collectively referred to as the student routes. So the student routes are made up of the student and child student routes for both EEA and non-EEA nationals who come to the UK for the purpose of study. And notice this route is the first to be simplified in accordance with the Law Commission's report simplifying the immigration rules. And notice there, the immigration rules will eventually be consolidated in the new style. So this is the sort of framework for the way things are going. What are the main differences? Well, 7.4, EEA nationals now incorporated into a global application system. Look at bullet point 2, increased switching permissions within the within the study route, and increased switching between routes within the points-based immigration system. Students will be able to apply for further permission from within the UK, provided they meet the academic progression requirement and the new course of study commences within 28 days of the expiry of the current leave. Let's go down to the next bullet point, quite an important one because it's affected some of my cases over the years. The 8-year time limit on studying courses at postgraduate level has been removed. There is no longer a limit on the time that an individual can spend studying postgraduate courses. Applicants who apply for permission to stay in the UK will not be required to provide evidence of maintenance funds when they've spent longer than 1 year in the UK on their current visa. Students at higher education providers with a track record of compliance will not routinely be required to provide evidence of academic qualifications used to obtain the offer of sponsorship. Students who will be applying for leave as a student union sabbatical officer or to study on a recognised foundation programme will not be required to provide evidence of maintenance funds, as it is accepted that these individuals will be earning an income during the validity of their visa. So you'll see at 7.5, they're introducing new rules on English language and finance. You've got these new appendices, which will only apply to the new student and child routes at this stage, with the intention that it'll apply across different routes as the immigration rules are simplified. And look, applicants only need to prove the required English language to the Home Office once they've updated the majority speaking English language country list. No longer require applicants who've met the maintenance requirement on their current route to meet it again if they've been supporting themselves in the UK for more than a year. Allow reliance on electronic bank statements. Allow applicants to show they meet maintenance requirements by relying on a wider range of accounts. So then we have all the technical changes that have been made to the various rules. And I say, do look at the detail of the rule. This is not the point of this video to go through the details themselves. So remember I said this won't kick in really for EEA nationals until next January. EEA National 7.7 is subject to transitional arrangements until the transitional period ends on the 31st of December. An EEA or Swiss national who makes an application in the UK under the new student or child student rules before 1st January 2020 will have their application rejected. They won't be considered, since they continue to have freedom of movement under EU law and are entitled to apply under the EU settlement scheme. So if you've got rights into the settlement scheme, this is not for you. This is for after January 2021 for EEA nationals. If they're outside the UK, EEA nationals who apply under the student or child student rules from outside the UK will only be granted leave that commences on or after 1st January 2021, provided they meet the requirements of the route. They've refreshed the reduced documentary evidence list, which was formerly Appendix H. And they've included, as you'll see, the EEA countries now to those who have the reduced evidential document requirement. And I'll show you that in the rules themselves in a moment. So the old Tier 4 general and Tier 4 child routes close on the 5th October 2020 at 8:59 a.m. So up until then, you can apply into the old routes. From 9 o'clock on the 5th of October 2020, you have to apply then under the new provisions. So that is the explanatory memorandum. Have a look at that. Let me just flick over now to the statement of changes itself. And what I've just, to give you an example, I've put up on my screen here Appendix ST. So this is the new appendix for student applications. The other one is for child student. So this route is for a person aged 16 or over who wants to study with a sponsor on a course of further or higher education, a pre-sessional English course, a recognised foundation programme on the doctorate extension scheme, or to take an elected post as a student union sabbatical officer. We've got the list of student sponsors. Some students can bring dependent partners and dependent children. For example, if they're studying at postgraduate level or on a government-sponsored scheme, the student route is not a route to settlement. And notice the change in language. And you may have picked this up. There was a bit of commentary on this on social media when the statement was laid. But now, instead of leave to remain, it's been changed to permission to stay. So we've got entry clearance or permission to stay. So there's a simplification in the language being used. And so you've got the validity requirements here. Notice now, ST 1.2, that having a CAS, a confirmation of acceptance of studies, for studies, is part of the validity of the application. So here's your validity requirements. Suitability refers back to part 9 of the immigration rules, not in breach of immigration laws except where 39E applies. Then you've got your eligibility requirements, and look at your points table. Like the skilled worker route, it's 70 seems to be the magic number. So you can see 50 for the study requirement, must meet all of those, 10 for the financial and 10 for the English language. We've got permission then in relation to the confirmation of acceptance for studies, course requirement, approved qualification requirement, level of study, place of study, financial requirement. You've got London and outside London. There's your English language requirement, and of course, academic progress requirement. Pre-sessional course, post-grad. Maximum period of study, and we talked about that, they've got rid of it for postgraduate. Documents use parental consent, and here's that differential evidence requirement. So they've added the EEA countries to the differential evidence requirement. So it says evidence to show that an applicant meets the financial requirement, and the requirement to provide documents used to obtain an offer does not need to be provided with the application, but may be required by the decision maker if the applicant is applying from a country or territory where they're living, or from the UK, and the applicant is either, and there's British, national, overseas, and then there's this provision there including all the EEA countries now that has been added to it. And you've got all your conditions there. So that's how the new Appendix ST looks, and there's a similar look then to Appendix CS for child students. And we're going to see this is the direction of travel with the simplification of the immigration rules. So as I said, have a look, because the devil is in the details, as you'll see as I scroll through the screen. And look at that. Let's finish there. Genuine student requirement. The applicant must be a genuine student. We've talked in other videos with sole representatives of the introduction of a genuineness test. Well, there it is, ST 5.1, a genuine student requirement. So there's that genuineness test there within the appendix. So have a look at the rules themselves. This is just a big picture overview of the changes that are to come. And remember that key date and time, 5th of October, 2020 at 9 AM. I hope this has been helpful to you. Have a look at the links below this video. Thanks a lot.